Welcome back to News Talk. A Supreme Court decision is being hailed as a victory for federal workers who blow the whistle on wrongdoing within their agency. Joining us now with an in-depth look at what the ruling means for agency personnel going forward, Cheri Cannon. She's a former ethics officer for 3 federal government agencies. She's now an attorney at the firm Tully Rinckey. Welcome. It's so good to have you with us today.
Well, thank you and good morning.
Talk about this ruling. What did the court hold?
Okay. Yesterday, the Supreme Court, in a 7-2 decision with the conservatives and liberals joining in the majority, said that Mr. Maclean, who was a federal air marshal who was fired in 2006, had the right to disclose information that was marked sensitive security information, not classified, and that disclosure was not prohibited by law, because it was not, and therefore his case could go forward over his firing.
What concerned him? What did he think was not as it should be?
Okay. Back in the early 2000s, following 9/11, the Federal Air Marshal Service got a great boost in people and resources, and he was one of the ones hired following 9/11. In the following years, obviously, there's a lot of security concerns about what is going on in this country. There was an alert given by Homeland Security that there were potential hijackings on long-distance flights. He was an air marshal, got a briefing on that. Simultaneously with that, though, however, the Air Marshal Service, for whatever reason, decided to cut air marshals flying on long-distance flights out of certain cities, including Las Vegas, which is where he was stationed. He was so concerned that the Air Marshal Service was issuing an alert as to possible hijackings at the same time it was cutting air marshals off of the flights, that he went and discussed this with his superiors and expressed his concern. They told him it was a financial concern, that they could not afford to keep people in hotels when they got to their destinations, and that's why they cut it. That didn't seem to cut it for him, and he took it to other people within the agency, including the Inspector General's office, who said we can't do anything about it. He then went to various media outlets, did not disclose his identity at that time, and expressed his concern, which ultimately Congress took up and raised some questions as well, and the service was restored. Fast forward a few years, and through other media contacts that he has made, he was disclosed. It came out that he was the one that had disclosed to the media the issues about the cancellation of the marshals flying on the long-distance flights during a period of heightened security, and he was fired.
Was it a sense of compromising government plans and policies that would potentially help those who would want to get on a plane and cause harm? In other words, if this flight is less likely to have the protection of an air marshal than the other one, it's sort of
yes.
intuitive where how a hijacker, a potential hijacker, is going to proceed with plans.
Absolutely. His concern, which should be every traveler's concern, is that during a period when there's heightened concern over hijacking, that at the same time TSA is cutting resources to those very flights, the long-distance flights, where they're more likely to be hijackings occur, like in 9/11. All of those flights were intended to be long-distance flights.
How did this end up? But I didn't. Sorry if I interrupted you. Go ahead. Did you want to finish the thought?
No. And so his concern was exactly what you expressed, that it doesn't make any sense what they did, and to save money is kind of short-sighted when the long-term plan is to protect the flying public.
Who went after him?
His employer went after him. What happened here is once TSA and the Department of Homeland Security discovered that he indeed was the whistleblower or the person who went to the various media outlets, and Congress got a hold of it, they fired him, and claiming in this case that he could not make that disclosure because the information concerning the security of those flights was protected security information. That does not mean it was classified in the sense that you and I understand classified, secret, top secret, and beyond. It's not classified information, which he clearly could not disclose. Instead, the agency had passed a regulation in order to protect certain information, this being one of them, about certain flights and security risks on certain flights, and had marked this information as sensitive security information. TSA took the position that he could not disclose that and that he violated their regulations, and therefore they fired him.
You mentioned at the outset, and I want to come back to it, that this was a 7-2 ruling from the court. How did they get to such a lopsided outcome where just about everyone on the court, and we know this court is quite diverse in its view in where the justices are on many big issues of the day. How did they get to a 7-2 ruling in the employees' favor?
And that's what's so interesting about this case. The basic concepts underlying the case, what is a law a regulation, are very basic concepts that you learn in law school. The question of what does law, rule, or regulation mean? How do you construct a statute? How do you understand what Congress intended? That is all very basic legal stuff that even a first-year law student understands. And that's why 7 justices to 2 ruled in this manner.
The notion that the words have their basic meaning.
The words mean what the words mean.
Yeah.
Where the twist comes in this case is that it's about a federal whistleblower. And so the import of this case is not in the a law means law, because everybody knows that. The real import of the case is because they were reviewing the Whistleblower Protection Act, and what does it mean? And so if it had been any other statute, we probably wouldn't be sitting here today. But because it was the Whistleblower Protection Act, and what does it mean in that context for an entire, hundreds of thousands of federal employees, that's why it's so important.
That's what I was hoping you would expand on next, given your expertise in this area. What is the early sense of what this ruling means going forward?
Okay. It means a couple of things. It means writ large, in a large sense, people who work for the federal government that are concerned about the agency's mission and doing the right thing for the American public, which this gentleman certainly was concerned about the safety of the American traveling public. People like him all over government now have a clearer understanding of what they can and cannot disclose outside their agencies in order to be protected. That's a great leap now, because the way Homeland Security was interpreting this regulation made it very fuzzy about what was protected and what wasn't. So for the vast majority of federal employees now, not in the intelligence communities obviously, they can now rest a little easier when they feel concerned and get no traction inside their own agencies, that when they go outside they're protected. That's the big picture. For him personally, the issue will be going back, where do we go now? And it needs to go back. The board never ruled on the actual issues of, was he a whistleblower? Did he disclose an issue that was a matter of substantial danger to public health and safety? And did the agency fire him because of his disclosures?
Is he trying to get his job back?
I believe that's what he would like, yes.
So here's the question I want to ask. It'll take a second to ask it, but when I hear whistleblower, and I think when many people hear the term whistleblower, they think, okay, there's a fraud going on, some kind of sweetheart arrangement. Maybe we're going with a contractor that's not offering the best price because of cronyism or kickback, whatever.
Right.
Or there's a program that slam dunk, it's not working, and this is money down the drain, and I'm angry, and I don't want, and my boss won't do anything. So, but I'm not going to be silent. So I'm going to do what I need to stop this waste. That's what I think of classically.
Right.
Maybe not exclusively, but that's like the classic whistleblower thing. Here you're talking about spending priorities. No one has all the money they want, so isn't it expected that you take the money you have and you do the best with it, even if you as an individual worker think it's not perfect?
Yes, it isn't really, it is about that, but it's not about that. So what this case is primarily about is the security concerns that he was raising. What he was saying was the agency's reasons for canceling these flights, i.e. fiscal concerns, should have been far outweighed by the national security implications of taking the air marshals off the flights. And so he was raising, when you were a whistleblower, yes, your classic definition of whistleblower, waste, fraud, and abuse is absolutely the case. But there's a whole other class of whistleblowers who disclose a specific and substantial danger to public health, or in this case, public safety. And you will see that more and more, I think, coming through in these decisions to come that are now going to follow on to this, is what is a danger to public safety. I would argue, and I think Mr. Maclean would argue, that taking air marshals off a long-distance flight during a period of heightened security concerns over hijacking is probably a substantial danger to public safety.
We only have about a minute left. You referenced 2006. Do these things typically take a long time? It sounds as though this matter has been bumping around in the system for 8 years. Correct me if I'm wrong.
No, it takes that long. It's unfortunate. When a federal employee gets terminated or removed, as Mr. Maclean was, his recourse is, of course, unless he's exempted from the statute, he's entitled to go to the board, which he did. Once the board turned him away and said, no, you were fired properly, he followed all of the procedures to appeal that through the proper procedures. He went to the Federal Circuit. The Federal Circuit actually reversed the board and said, no, you're wrong, Air Merit Systems Protection Board. This is, they did the statutory construction and said he didn't violate a law when he did this. It was not prohibited by law. What was unusual and took so long in this case, as you know, it takes forever to get a case to the Supreme Court. The government took the case to the Supreme Court, and that is very unusual in the case of federal employees, and that's what's remarkable about this case, given the simple, basic legal precepts.
A very fascinating case, and an area that impacts a lot of people because so many people work for Uncle Sam. Cheri Cannon with the law firm Tully Rinckey, thank you very much for helping break down this really complicated but fascinating case. Good to have you with us.
Great, thank you.
We'll step aside, back with more right after this.